In my last video about Corey's plea hearing, attorney Creighton Waters mentioned a case involving Corey's family members back in 2012 where Alex and Corey reversed roles and pulled off a shady precursor to the Satterfield situation. Let's call it the Shady Lawyer Shuffle. I dug up the case and a little information about it. Are you ready to hear the details? Let's get started. This is Cassidy O'Connell with Legal Updates with Cassidy. Episode 7, The Shady Lawyer Shuffle. Welcome. The case involves Corey's wife, who is also an attorney, for an accident involving her vehicle, but not an actual car accident. The first document, the summons and complaint, were filed on August 6, 2012. I couldn't help but notice that this coincides with Corey stealing the Pinckney money. This around the same time period. Now, we have our first red flag. Do you see what I'm talking about? What's wrong with this? Notice the address he put. It's the correct address for Alex, but right above Alex's name, instead of PMPED, we see Corey's law firm, Moss, Kuhn, and Fleming. Does this mean Corey actually drew up this document and forgot to change the law firm name? What does it mean? Whatever it means, on this legal paperwork, Alex posts as if he's an attorney for Moss, Kuhn, and Fleming. Is this okay? Let's look at some of the rules regarding this. First, we're going to look at Rule 1.7. Lawyers may not imply or hold themselves out as practicing together in one firm when they are not a firm, as defined in Rule 1.d, because to do so would be false and misleading. Rule 7.5d, lawyers may state or imply that they practice in a partnership or other organization only when that is the fact. So, this could have been an accident, but it should have been picked up by the judge. But let's go beyond that, because it's not just this situation with the law firm name. There's also a conflict of interest here. In this lawsuit, Alex is suing Corey's wife. And if we look at Rule 1.7, it starts off by saying, except as provided in paragraph B, a lawyer shall not represent a client if a reasonable lawyer would conclude that either 1, the representation will involve the lawyer in representing differing interests, or 2, there is a significant risk that the lawyer's professional judgment on behalf of a client will be adversely affected by the lawyer's own financial, business, property, or other personal interests. Now, Corey is Alex's best friend. They were law school roommates, yet we find Alex is suing Corey's wife. Is that not a conflict of interest? Now, point B says, notwithstanding the existence of a concurrent conflict of interest under paragraph A, a lawyer may represent a client if, and then it lists several things here, but we're going to go down to the last one. Each affected client gives informed consent confirmed in writing. No such written consent shows up in any of these filed documents. We can move on to Rule 1.8 for a little more information. The lawyer shall not enter into a business transaction with the client if they have differing interests therein, and if the client expects the lawyer to exercise professional judgment therein for the protection of the client. I would say there's some differing interests involved if you're suing the wife of your best friend. But it again mentions giving informed consent and having in writing signed by a client, none of which took place. Now, would this involve their situation? At the very bottom, it says, for purposes of this paragraph, related persons include a spouse, child, grandchild, parent, grandparent, or other relative, and here's the important part, or individual with whom the lawyer or the client maintains a close familial relationship. How related is Corey considered? Notice it says an individual with whom the lawyer or the client maintains a close familial relationship. It doesn't require actual blood relation, but in this case, Corey is the godfather to at least one of Alex's sons. So here we start off on just this one first page with a glaring red flag. Page 2, which begins the complaint, shows that Jean Folks is the duly appointed guardian ad litem since the injured party is a child. Then we get to the details of what happened. that on August 1st, 2010, the minor child was a passenger in the vehicle being operated by the defendant when she caused the minor child to exit the vehicle from the rear of the SUV. The minor child slipped on the wet bumper rack and fell to the ground, severely breaking his arm. Now, this next part sounds really bad, and part of me hopes it's an exaggeration because I would hate to think of a child suffering this way, but it is in fact a serious infection that can cause the bone to die, and even the child himself. So I don't want to downplay what happened to the child in this situation. We're just talking about the shady lawyering. It says that he suffered physical injury, which was a bone forearm fracture requiring multiple surgeries and long-term recovery. He developed osteomyelitis, which required additional surgery for this life-threatening bone infection. He incurred medical expenses, suffered pain and mental anguish, lost school, lost enjoyment of life, and all of his damages are permanent into the future. Just a reminder to have small children exit a vehicle in the proper way. We see they've asked for a jury trial, and naturally, a trial that involves an injured child is really good for bringing sympathy from a jury. Next, we get an answer from Eve Fleming, which is Corey's wife's law firm, Clausen and Staubs, denying each and every allegation. Clausen and Staubs, by the way, is a large firm operating in multiple cities in South Carolina. The next filing we have in the case is dated September 25th, 2012, and it's the petition for appointment of guardian ad litem, where we learn that Jean is a cousin to the injured minor. And on the same day, the petition is granted and the order is filed. Now here's where things get even more interesting. We come to the scheduling order. We've talked about those on here before. That's the court-ordered schedule to keep trials orderly and on time. It tells us that the mediation must be completed by December 1st, 2013, and the trial not before January 3rd, 2014. But look at this. Now that's a familiar name. The one judge who knows more than any other judges in the area the relationship between Alex and Corey. She is a fellow law school classmate of theirs. She's so close to Alex, in fact, that she had to recuse herself from the boat crash trial. But here she is presiding over a case with Alex suing Corey's wife, and it's all fine, not shady at all. I also noticed that this time on this document, Alex uses his actual law firm's name. But still, there are no disclosure statements or written consent acknowledging the relationship between Alex and Corey here. On March 12th, 2014, a petition for minor settlement is filed. We see the settlement to be, for the medical expenses, $65,700 to date. $25,000 of that from USAA Insurance Company and $95,000 from a UIM policy. That makes a total settlement of $120,000 and attorney's fees of $48,000 to be paid to Alex. This is very odd that Alex doesn't receive the usual 30%, which would be $36,000, but instead he gets $48,000 or 40%. Very odd indeed. And then on the same day, that petition is granted and turned into an order, and the order is signed. And here we see the amounts in the order are approved, the same amounts. $120,000 total, $27,000, but that's still pending because medical expenses can go on from this point. And then the $48,000 or 40% attorney's fees to Alex. Then the case is officially dismissed on May 7th, 2014. But while Creighton was speaking about this case, he said Corey basically handled it. It was just done in Alex's name, just like how things were done for the Satterfields. Alex handled everything, but it was all put in Corey's name. He also said that the attorney's fees were split between the two of them. Now, I don't have access to the financial records to show that here, but Corey and his lawyer did say that there were things that they disagreed with that would be addressed during the sentencing hearing. So we'll have to wait till then to see if this is one of those things. Lots of exciting things are happening in September, and I can't wait to share all of those with you. In other news, Fox Nation has allowed a few excerpts from their upcoming special about the Murdaugh family. Specifically, the first ever interview with Buster, where Buster tells them that he still believes in his father's innocence and that he's never wavered in that. He also says that he fears for his life still, so he regularly takes precautions. He also may have alluded to his father being a sociopath. We'll have to hear that part in full to see if anything was taken out of context. He also expressed his shock at hearing that his dad was actually at the dog kennels that night, because he too had been told the lie that Alex wasn't there. I'm eagerly awaiting that whole interview and will be sure to discuss it here with all of you. Till then, this is Cassidy O'Connell saying stay well and stay tuned.